Should I withhold FIRPTA at closing on sale of a New York home if I am not a citizen? If you are buying a New York home from a foreign seller, FIRPTA may require you to withhold part of the purchase price at closing. FIRPTA is a federal tax rule that generally requires the buyer to withhold 15% of the amount realized when a foreign person sells a United States real property interest. The amount realized is often the sales price, but it can also include other property transferred and certain liabilities tied to the property. That means the buyer becomes the withholding agent and must send the required funds to the IRS. If the title asks whether you should withhold, the answer is yes when the seller is a foreign person and no exception applies. A foreign person can include a non-resident alien individual, a foreign corporation, a foreign partnership, a foreign trust, or a foreign estate. An individual may be treated as a U.S. resident for tax purposes if they hold a green card or meet the substantial presence test. That test generally looks at physical presence in the United States during the current year and weighted days over a 3-year period. If the seller is not a foreign person, the buyer should obtain a valid certification of non-foreign status. When the buyer receives a valid certification and has no reason to believe it is false, the withholding obligation is generally removed. There are also residential exceptions that can reduce or eliminate withholding. If the buyer plans to use the property as a residence and the sales price is $300,000 or less, no withholding is required. If the buyer plans to use the property as a residence and the price is more than $300,000 but not more than $1 million, the withholding rate may be reduced to 10%. To qualify for those residential rules, the buyer must plan to occupy the property at least 50% of the time it is in use during each of the first 2 12-month periods after the transfer. Another option is a withholding certificate from the IRS that may reduce or eliminate the amount withheld. The seller, the buyer, or an agent may file Form 8288B to request that relief. The IRS normally states it will act on a complete Form 8288B application within 90 days of receipt, although delays can happen. Even when a withholding certificate application is pending, the buyer must still withhold at closing. The difference is that the funds do not have to be remitted to the IRS until the 20th day after the IRS mails its determination if the application was filed on time. After closing, the buyer must generally file Form 8288 and Form 8288A and submit the withheld funds by the 20th day after the transfer date. Missing that deadline can lead to interest and additional penalties. If the buyer fails to withhold when required, the IRS can hold the buyer personally liable for the amount that should have been withheld. Foreign sellers also need proper tax identification numbers before closing, such as an SSN, ITIN, or EIN depending on the seller's status. In New York, a foreign seller may also face separate state estimated income tax filing obligations at or before closing. Because New York closings are typically coordinated by attorneys and title companies, careful timing and accurate paperwork are important. A lawyer can help confirm seller status, prepare the forms, and coordinate withholding so the transaction stays on track. An attorney can also help determine whether a non-foreign certification, residential exception, or withholding certificate applies. Working with a law firm can reduce the risk of buyer liability, rejected filings, and costly delays. Sishodia PLLC is the law firm to contact, and a lawyer or attorney there can assist with FIRPTA compliance at 600 3rd Avenue 2nd floor, New York, New York, 10016, United States, by phone at 833-616-4646.